All right. So under the Constitution, in Bill of Rights, Section 22, it stated that no ex post facto law or bill of attainder shall be enacted, meaning it's also one of the constitutional limitations on the power of Congress. A bill of attainder is actually a law or a statute that imposes penalty without a judicial trial. Ibig sabihin, you are depriving the person of the accused of his or her rights, whether civil or political, without the benefit of a fair trial. Kaya walang pagkakataon na um, ma-prove yung kanyang guilt beyond reasonable doubt, which is the measure in a criminal offense. Kailangan ma-establish yun as parts or as a rule of evidence. Bail of attainder is, in its essence, a substantial legislative fiat or a judicial determination of guilt. Talagang yung batas na yon, kung yun man ay gagawin, no, ay sinupersede niya or kinukuha niya yung dapat na trabaho ng judicial department, no, or the courts in determining the guilt of a person. So that is, again, not allowed by our Constitution. Another is on the ex post facto law. Ano ba ito? Ibig sabihin yan, no? Ibig sabihin ay under the revised penal code, it states that no felony shall be punishable by any penalty not prescribed by law prior to its commission. No? Kumbaga, kung wala pang batas na nagpa-penalize for the particular act, then it must not be punishable. Or yung Latin maxim na sinasabi na uh, there's no crime when there's no law punishing it, na yung gaya ng na-mention ko kanina, na nulung krimen, nulung pena sinilihe. No? Or there's no crime when there's no law punishing it. So, ilan sa mga examples of an ex post facto law ay kapag ka ang act or omission ay ginagawang kriminal when it wasn't criminal during the actual commission or omission. No? Nung ginawa yon, this year, walang batas na nagpe-penalize. Next year, may batas na nag-penalize, hindi siya pwedeng mag-retroact to penalize those acts that had been committed this year. No? So, kasi ang tatandaan natin in the discussion on ex post facto law, merong mga characteristics yan. One is it refers to specifically criminal matters. Second is it is prejudicial to the accused, unfair, no? Para sa kanya. And it's usually retroactive in application. Ang tatandaan natin, ang rule of thumb would be if it is made to be retroactive, then it must not be prejudicial to the accused. Pagka prejudicial yan sa accused, it will fall under the purview of an ex post facto law. So, another example ay kapag it aggravates the seriousness of the crime than when it was committed, mas pinapalala niya yung penalty or uh, yung circumstances of the felony, it imposes a penalty that is higher than when the crime was committed, no? Kaya ina-aggravate niya. It makes it easier for the prosecution to establish the guilt of the accused than when the crime was committed. So, limbawa, sasabihin na hindi na guilt beyond reasonable doubt, yun, hindi na pwede yun, no? That should not be allowed. It requires a lesser quantum of evidence than when the crime was committed. No, I was referring to, again, proof of guilt beyond reasonable doubt. Dahil pagka binaba mo yan to the level of a civil liability, mere preponderance of evidence is enough to um, make one punishable or be accountable or liable. Another example is if it alters in relation to the offense or its consequences the situation of a person to his disadvantage. Another, it assumes to regulate civil rights and remedies only, but in effect, it imposes a penalty or deprivation of a right which, when done, was lawful. Another example is when it deprives a person accused of the crime on of some lawful protection to which he has become entitled, such as protection of a former conviction or acquittal or a proclamation of honesty. Kaya nga, yan yung sinasabi din natin na double jeopardy, no? Hindi po pwede. Na-acquit na siya sa ano na yon, sa kaso na yon, hindi pwedeng i-file uli against the same person for the same acts or omission, no? Dahil mako-cover na siya ng sinasabi nating double jeopardy. Okay, so before going further on the discussion on felonies or what are crimes, kailangan nating intindihin din kung ano yung mga characteristics of a penal law. So meron tayong tatlo. So basically, we are looking at generality or that it must be applicable to all persons governed or it must be binding on all persons who reside or sojourn in the Philippines, whether citizens or not. No? The principle of generality. Another is on territoriality, meaning jurisdiction or the place where applicable. It means that the law is applicable to all crimes committed within the limits of Philippine territory. So intindihin din natin kung ano yung Philippine territory later on. And then the third one is on prospectivity, that the law should only have prospective application except if it's favorable to the offender. Kasi if it's not favorable, then it is an ex post facto law. It is prejudicial to the offender or to the accused. So hindi po pwede yun. But if it's favorable to the accused, then that's fine. No? That would be allowed. Okay, so let's start with going a little bit deeper dito sa generality, no? The principle on generality. Remember that as a rule, criminal laws are binding on all persons who live or sojourn in the Philippines. subject to the principles of public international law and to treaty stipulations. Ano ba yung mga exemptions? Treaty stipulations, exemption yan. Anong example niyan? Yung Philippine and US Mutual Defense Treaty, no? Yan, that's a treaty stipulation. How about yung sa mga public international law? Meron tayo, no? Halimbawa, yung sa Vienna Convention on Diplomatic Relations, it states that diplomatic agents are exempted from criminal jurisdiction of the receiving state due to the principle of parem parem non habet imperium. So, ibig sabihin, an equal has no power over an equal. Dahil yung diplomatic agent ay treated as the representative of their own country. No? So, a country cannot penalize, no, or has no power over another country. No? Magkaiba yung diplomatic agents with the rights of a consul. No? Kailangan tandaan din natin yun. Right? Another is on the warship rule. No? A warship of another country, even though docked in the Philippines, is considered an extension of the territory of their respective country. Yan yung nasa UN clause, no? Or the Convention on the Law of the Sea. Hindi po pwedeng tingnan natin, kumbaga, mako-cover itong mga nasa yung warship, no, of another country, that even though that particular warship is docked within the Philippine territory. Pangatlo would be laws of preferential application. What is this? Persons who are exempt from arrest and imprisonment and whose properties are exempt from restraint, seizure, and attachment are or includes ambassadors and public ministers of any foreign state, domestic servants of ambassadors and public ministers, so, yung kanilang mga house helps. Another would be yung provisions on bigamy in the revised penal code shall not apply to persons married under the PD 1083 or the Muslim law. No? Kasi iba yung, it's a special law and iba yung kanya provisions compared to the ones that are provided in our revised penal code as well as on the new civil code of the Philippines. Okay. So, tandaan natin that in applying the generality of a penal law, it must be binding upon all persons, again, who live or sojourn in the Philippines, irrespective of age, sex, color, creed, or personal circumstances. When being applied, no, itong principle of generality, it has no reference to territory. Okay, ibig sabihin, when ano yan, kahit or ano ba yan yung sinasabi nga na whenever you are asked to explain this, hindi siya kailangan lens, no, or hindi mo kailangan i-limit or restrict to the territory, no, because it refers to persons, no, anyone who live or sojourn to the Philippine can actually be governed by the penal laws.